Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jeffrey Hare, and Jeffrey is an attorney in San Jose, California. He provides client-focused, outcome-oriented legal services to his clients. He is also a licensed real estate broker and real estate investor. Jeffrey specializes in real estate law, real estate property transactions, entity formation, commercial leases, loan documents, land use law, zoning, land use changes, municipal law, and most important for our discussion today, mediation services. Okay. And so today we're going to be talking about settling legal disputes out of court, which is also known as alternative dispute resolution. Now, as we get started, I want to caution our viewers, as usual, that we are discussing issues in a very complex area. Jeff went to school for a long time to learn this stuff, and I guess now you're teaching some of this stuff. Is that right? Anyway, so this is a starting point for a continuing discussion with your own attorney, and we want you to get qualified legal and tax advice. So with that, Jeff, let's get started. And again, welcome.
Thank you.
Welcome as our guest again today. All right. Well, what is this alternative dispute resolution stuff, or ADR, and why do I need to know how it works?
There are a couple of reasons you need to know more about it, and probably more now than before, is that the process of litigation gets extremely expensive, and a lot of people, in attempts to try and resolve disputes, are finding more and more that the process, which we used to call alternative dispute resolution, and it's still called ADR, is now the more preferred and much more common way of solving conflicts or disputes. Moreover, over 90% of all cases actually settle before they get to trial. So at some point along in the process, if you're in a dispute, a legal dispute with another party, you're going to go through several stages of attempts to settle and to negotiate a settlement to the case before the jury ever gets to see it. And so the more you know about the settlement process, the more that you realize that that's what's going to be the outcome, the sooner you can settle, obviously, the least expensive it's going to be.
Okay. So you were telling me the other day, we were talking about this stuff, that there's some recent developments that have happened in our judicial system in California that make alternative dispute resolution even more important than ever. So maybe you'd like to comment about that a little bit.
Yeah, it's pretty serious. We're now, I think, in the third year of drastic budgetary cutbacks. The state took over the operation of the superior courts from the counties a few years ago, and it was an attempt to standardize the process so that you didn't have poor counties and rich counties having a disparate process for the judicial system. And now the state is being hit with, of course, huge budget deficits, and they're cutting back in all areas, and the courts are not immune. This year alone, they're looking to cut $660 million from the budget. 310 of that is going for facility upgrades, and 350 million cuts in programs. So San Francisco Superior Court system just laid off 200 employees and closed 25 of 63 courtrooms.
Holy mackerel.
So you're going to see a lot more of this going on and around the state as the results are coming in. And again, it's not over. San Francisco is facing an $11.5 million deficit next year. So their cuts are going to continue. It's going to cut back on staff. It's going to cut down on the availability of judges. And literally courtrooms will not be available for the litigants, which means in the civil arena, which is where most of my clients end up, is going to find it very hard to get a case heard.
Wow. Yeah, so it's just making it extremely difficult. Hopefully you can find judges to even rubber stamp your settlements. Right. Okay. All right. So why is litigation so expensive?
Well, there's two reasons. One is time. Attorneys charge by the hour, and the cost of litigating as it becomes more complicated, as there are stalling tactics, as there are delays, the cost of just the time of an attorney to go through the case, to become familiar with it, and to get up to speed professionally on a matter does involve the use of money. Also, there's a lot at stake. A lot of times people don't realize that, stop and pause to see what is the consequences of not having an attorney, and weighing that against the cost of the attorney's time. But mostly it's all costs have gone up across the board. So it's a magnifying effect, a multiplying effect, I should say, and that litigation, due to the time, the cost, and the materials, everything becomes just that much more expensive.
Yeah.
And the other thing is that attorneys are more and more, like doctors, of having to follow the professional responsibility and trying to keep up with it. They can't just glance at a case and write a quick letter and hope that it's over. They really do have to do the research. They really have to understand the procedural requirements. This, again, takes time.
Okay. So this alternative dispute resolution, you're saying 90% of cases are being settled in this way. Is it becoming like mandatory, or is this an optional approach? Or?
Well, maybe if you look at the anatomy of a lawsuit, from the time a party decides to, they can't solve a case. Two business owners can't decide how to split the proceeds, or they formed a partnership and they want to break up. Or if you have a real estate transaction, that there's something discovered somewhere along the line where the parties now want to separate. If they can't work it out, they have to go into a process that now requires, according to the documents they signed, either mandatory mediation or mandatory arbitration, depending on what the forms say. So even before anything is filed in the court, it is often mandatory by virtue of the contracts they signed that they have to go through a mediation or an arbitration process. Once they get into court, the court will then order them to arbitration. And at some point along the line, they may seek voluntarily to go into mediation.
Okay. What is the difference between mediation and arbitration?
Many people get them confused. It's a common mistake.
Well, we're not all lawyers,
That's right. A lot of times clients, what is this arbitration? What's the difference? Well, first of all, arbitration is less formal than a court trial, but it has the process where each party submits their information, their side of the story, to a neutral who then renders a decision. And the neutral renders a decision either in a binding format, if the parties have agreed to a binding arbitration, in which case it sticks, or it's a non-binding decision. In other words, it's more or less, here's what the ruling is, and the parties then can decide to appeal it or to take it to further legal review. Non-binding arbitration is, someone would ask, well, why even bother if it's not binding? Well, non-binding arbitration often gives the parties the independent review and a perspective they may have not seen. They find their case really isn't as good as maybe they thought it was.
Okay. So you've talked about binding and non-binding arbitration. What is the difference? What does this stuff mean?
Well, if in the judicial arbitration is considered to be non-binding. If after you've filed a case in the court and they send you to non-binding arbitration, neutral will review the case, and the non-binding ruling is made and says that party A gets $100,000. Well, party A says, great, I won, but party B isn't too happy with that. Party B then can appeal it and go back to the court and say, we're going to trial. So they can reject the award. In most cases, of course, we're seeing more and more, especially with large public employee unions and groups, they have what is known as binding arbitration to resolve disputes over pay. That's a term that's used a lot, so I just wanted to throw it in that context.
Right.
If it's binding, the parties have agreed in advance that whatever the neutral arbitrator rules will be the ruling, and there's no appeal from it. So again, one of the advantages of what we call ADR, or alternative dispute resolution, is that there will be a final decision at some point, either voluntarily by the parties mediating and reaching an independent decision amongst themselves, or by sending it to an arbitrator and avoiding the costs of trial and appeals and further delays.
Okay. What are the advantages? It seems like an awful lot of contracts these days have this binding arbitration clause in it, or whatever, or some sort of a clause related to these alternative dispute resolution approaches. So what are the advantages and disadvantages of signing these clauses in a contract agreement?
Well, right now I think you don't have much choice.
Yeah, well, that was the second question, but anyway, we want to just...
If you want your contract, you may have to do it, but in a large number of real estate contracts, it is optional. In fact, under the standard California Association of Realtor form, it's the arbitration clause must be signed by both parties and to kick into effect.
Mm-hmm.
What's the advantage of it? One is it provides a mechanism for resolving the dispute short of having to go to litigation. Second of all, the other advantage for the parties is it gives them a chance to resolve the dispute before incurring the high cost of litigating in the courts.
Mm-hmm. But we were saying, in a sense, you may not have much of a choice, at least if you're deciding to go ahead and contract with this particular agency or company. If you're going to do it, you're going to sign their contract. It's got an arbitration clause. There you are.
Some of them, of course, you'll see if you're purchasing services or, let's say, a large contract from for equipment or something for your company, you'll find that the buried in the contract language in 9-point font type will say that this is subject to arbitration and the venue has to be heard in the state of Vermont or Virginia or somewhere very inconvenient for you in California. Some of these clauses are not enforceable in some ways, but the overall advantage of signing them is that, again, in the long run, if the case is going to settle anyway, this gets the process started sooner. Hopefully you'll get in and out of the thing, and it's a incentive to the parties to reach an amicable agreement early on in the process.
Mm-hmm. It seems like I'm thinking of particularly like stock brokerage type companies. I mean, it's pretty much standard or de rigueur, whatever you want to call it. It's just going to be there.
That's right.
And so, is it really binding?
Most cases it is. There is a statistic that I was reading yesterday that even after voluntarily settling cases, 20% of the cases that were solved through the alternative dispute resolution process, 20% of them find their way back into civil litigation because one or the other parties goes through remorse or finds that some fact or some piece of the information wasn't disclosed to them. Mm-hmm. This happens a lot, unfortunately, in family law cases where there's a lot of emotion attached to it, and there may be some issues, or there's changed circumstances that they claim should have been known at the time the settlement was reached. So about 20% of the cases find their way back into litigation after they've gone through the settlement process.
Okay. What is private judging, and how is that different?
Well, there's a couple of organizations out there. JAMS is probably one of the most famous judicial and mediation services that provide private judges. If you have large corporations with huge amounts of money at stake, such as the high-tech industries around here, they can't afford to take a case through 5 years of litigation to resolve a matter involving an intellectual property dispute where there's literally could be billions of dollars at stake. So they will hire a private judge, hopefully one with unique knowledge in the area of the high-tech industry, to come in and issue a ruling, and they can get to a resolution much faster.
Okay.